Hey everybody, this is Brian and welcome back to the podcast. Today I got something for you really exciting. You should be jumping up and down now because I'm pretty much going to introduce this guy to you. He's the constitutional man Carl Miller, aka a lot of other names because the government does not like him. Very, very knowledgeable on taxes. Question comes up a lot about, voluntary taxes. Do you have to pay taxes? This guy's going to tell you so much crap because he went 27 years without paying, and he went right into court, and he just chewed it up with what he's got. And I think everybody needs this information so you can do what's best for you. Yeah. This is all about Title 31 USC, Section 742, and how the government don't want you to know this. Matter of fact, in 94, they took this information and they hid it back instead of 742, it was back in 3,100. They were hiding it. And this guy is very knowledgeable. So let's get into this. Oh, before we do, I just want to let you know that the government knows by them collecting taxes is illegal. And listen to this video and you'll figure out why real quick.
I can bury you. Literally. Just to give you a little for instance, does everybody know that in every state in the Union they have no right to tax nothing? Why is that? Title 31 United States Code, Section 742 says very clearly, except as otherwise provided by law, all stocks, bonds, treasury notes, and any other obligations of the United States are exempt from state, municipal, and local taxation. This extends to every form of tax which would require that either the obligations and green things in your pocket or the interest thereon is how they do their property taxes, or both considered directly or indirectly in the computation of tax. See Memphis Bank versus State of Tennessee at L. Garner. Now, you have that packet in your file there. It's called Title 31, Section 742 Explained. And you know what happened in 1994 when they found out we knew about this? They moved it to Title 31 United States Code, Section 3,124, because it took the right of every state in the Union away from tax anything that's an obligation in the United States government. Now we go to Title 12, Section 411 of the Banking Code that says Federal Reserve notes are obligations of the United States government. You can't tax them. You can't figure a tax in them. You can't figure no interest in a tax on the interest. Now I can do this all day, folks, right off the top of my head. You keep messing with the American people and you will find out. They don't call me to walk in the law library for nothing in every federal court for a 200-mile radius where I live. I can burn your tail. I can show you how the United States government doesn't even exist in law since House Joint Resolution 192, June 5th, 1933. You haven't existed actually since 1861 at the Civil War when they sundialed the Congress. And they never had a date certain to meet back again. And when the Civil War was over, those weren't congressmen they sent to the South to take over, were they? They were overseers. Now, how did I get a 2/3 majority vote in the Congress on all the laws you passed? I didn't. So all the laws are illegal? That's right. Now, you want to mess with this old paratrooper? You come try it. They called me the Iceman in Vietnam. They had a good reason for that. I'm not going to play with you. I'm going to smoke your ass. Now, you fix this thing and you make the American people proud to be American again. And we shouldn't have to feel obliged to apologize for your sorry ass as you went out and did this fraud and then tried to involve the whole world in covering up where the money's hidden. You fix this and you damn well better do it good, because every time I come out here, I'm going to tell the people something real important. Imagine if every time you tried to charge them with something, they came back with a motion to quash, strike, and dismiss, failure to state a cause of action upon which relief can be granted. The United States is not a real country. They're nothing but a fiction of law. They don't exist in law. Why? They went bankrupt in 1933, June 5th, House Joint Resolution 192. What is a bankrupt corporation, Your Honor? Civilly dead. You don't exist. You got to have a trustee of the bankruptcy to even open your court. I've proved it. I asked the bailiff, go get me his card over there, that prosecutor from the United States Attorney. He said, I need to have the right address so I can send him the best papers, okay? He came back with the guy's card, and I said, excuse me, Your Honor, when he started speaking, this gentleman doesn't have a right to speak. What? What are you talking about? That's the U.S. Attorney. I don't care if he's a man from Glad. He doesn't have a right to speak. I have his card right here, and it doesn't say on there, trustee of the United States Bankruptcy Court. So I must assume that he's not a trustee of the United States Bankruptcy Court. He doesn't even have raised letters on his card, so he ain't real proud of what he does. I said, I submit this to the bailiff for your perusal, Your Honor. You'll see he's not a trustee. He doesn't have a right to speak, Judge. Only a trustee of the bankruptcy court can speak before this court on a bankrupt entity, and the United States is bankrupt. House Joint Resolution 192, June 5th, 1933. The guy stood up and says, you have got to be kidding. And the judge turned to him and said, shut up, sit down, I'll tell you when you can talk. 19 minutes later, I was walking out in my own recognizance, being charged with 27 years of income tax violations, and I ripped the floor right out from under him. All of you people out there can do this. All of you. Everyone. Every time these people want to charge you something, fine. Motion to quash, strike, and dismiss, Your Honor, failure to state a cause upon which relief can be granted. These guys are not a real body.
Slow down, honey.
They're not real. They don't exist. As a matter of fact, they're civilly dead, Judge. Isn't a bankrupt corporation civilly dead? Well, that's right. So they don't have a right to come before your court and speak nothing unless they got a trustee of the bankruptcy court with them. Well, that's
Slow
right.
down.
Well,
Slow down, Constitution man. You're going too fast.
I move for you to strike this complaint, Judge. He's not a trustee of the bankruptcy court. And that prosecutor got up, red-faced as hell, and that judge told him time after time, shut up. I said, sit down, I'll handle this. 19 minutes later, I walked out. I said, you know, Your Honor, and this is a true story, and I apologize because some of it's a little bit swear-wordy, but they charged me with 27 years of income tax. And I told them, I said, well, I've heard it said that a United States attorney can indict a ham sandwich. And everybody laughed. They thought that was real funny. And I said, but I'm here to tell you, this is a damn fool complaint. And if you bring this damn fool complaint, I'm here to tell you, you better crawl upstairs in that dusty loft on the 10th floor and pull out the real thick books, because I'm here to tell you I have already done that. And if you bring this damn fool complaint, I'm going to tell you to make my day, just like old Clint Eastwood. And the whole court was in shock. You could have heard the echo on Mars. And then everybody laughed, and then even the judge was laughing. And the poor public defender, they put the stand next to me, reached to heaven and looked directly in the ceiling where God was and said, why me? What did I ever do? 19 minutes later, I walked out of that court free as a bird in jail clothes with all the cops holding their guns, and the bailiff was escorting me to the front door saying, judge says let that one go, he's heavy duty. This can be done by each and every one of you. The time for worrying about crap is over. That's what I'm giving you tonight. And I'm giving you that because these guys deliberately didn't fix this, and I gave them 2 days. That's more than enough time to make a phone call and say, fix this.
You know,
made a phone call, and it would have all been fixed. But no. So now you reap the whirlwind. Have fun in court. And I'm telling every one of you, if you ain't having fun, you ain't doing it right.
That's right. How do you
I want you
handle
laughing. I want you laughing when you leave that courtroom. I want you to stand out in front of that courthouse, and I want you to take your fists out there and beat them on your chest and give them the, That's what I did. All the cops laughing their ass off. That's what that paratrooper, he's heavy duty. He will get you. He will get you. They didn't call him the Iceman for nothing. You should see the beautiful knife that they gave. All hand carved, and it's got alligators all over it. The Ranger Runner got for me. It was real nice. And on the bottom it says the Iceman, Ranger Airborne. And then it says the alligators talking to each other, and the paratrooper's coming out of the plane. He goes, here comes dinner. And this ain't a knife. This thing is a Roman short sword. I said, man, if you fell in the water with that, you'd drown. He laughed. Anyway, I gotta watch getting this wound up. You can tell I'm very passionate, and I bleed like red now. So I'm gonna just slow down a little bit now and share with you. I'm very angry about this. I'm very angry about my country and its good name being trashed all over the world by a bunch of Shylock jackasses that don't realize there's more to life than greed and money. And you're supposed to be gentlemen. Duty, honor, country, pride in the core was how I was raised by very fine soldiers, some of which can't be here today. One of them is that crazy soldier in that movie, We Were Soldiers Once and Young. That command sergeant major died in my arms, telling me, tell my wife, tell my kids I love them. 9 kids. The guy only had 9 days to go. He got shot. I told him, I'll take care of your Foot Locker store. Just stand in the damn hooch and don't go no place. No, he had to go out and take care of his boys, because that's the kind of guy he was. He got shot, and the general cried all the way to the hospital. I kept trying to tell him, take it easy, Sergeant Major. Everything's going to be fine. Just stay calm. We're only 5 minutes from the hospital. We'll be there any minute. We redlined the aircraft. We're going to be there any minute. Just stay calm. Stay calm. We'll have you in the hospital any second. We'll crash land the bird if we have to make sure we get you in there. Now, come on. My brave men died. A lot of them in my arms, and I'm pissed. This was supposed to be for the soldiers of America that fought these wars. They ain't getting a nickel. All them philanderers are down in Washington. They're cashing out in the back door and getting all the money, and none of the little people are getting the zip. Let alone the soldiers lying up in hospitals all shot. You haven't lived till you've been to a veterans hospital. I've been to veterans hospitals, and you know what the damn nurses did? They bet. We bet that we can get that old man over there to lift off the bed by 3 foot. And they actually took a bet on it. At 4 o'clock in the morning, they jumped me, put me in a chokehold. Well, now 4 o'clock in the morning, it's usually pretty quiet, you know what I'm saying? Not that morning. I came out of that bed, I cleared that bed easily by 3 foot. And all you heard going down the halls of that veterans hospital was, and all of a sudden, all them soldiers started laughing. And they laughed their ass off. And all day that nurse, hey, you jump into them old paratroopers lately? I'll bet you don't never do that again. You had to go home and change your blouse, didn't you? And he laughed him off the floor. And the doctor come up and found out my stitches got ripped because I was screwing around with this stupid nurse. That's when he fired that nurse and said, I'll never work in another hospital again. And he took me back up to emergency and stitched me up in an emergency.
Got some people lined up to ask you questions.
All right, let's do that next. I got that on the list next. We got to get some of the people some help. I hope everybody was taking real good notes there, because I gave you stuff that's 100% lawful. And I'm telling you, if you use it, you'll scare the bejeebers out of them. And they'll turn and look at each other, and the next thing you know, you're going to be walking out a free person. So let's start on Bushmaster.
Okay, first of all, Frank here wants to know, how do you deal with an employer? Hold on a second, let me find the message. The question. It was here a minute ago. Let me see. Hold on a second. Let's know how to deal with an employer that's, let's see here. How to deal with an employer that complies with an IRS tax levy, and how to deal with the IRS in court.
First of all, let me explain something to you. The tax is not deemed to be owing if it is not a proper assessment. Did everybody hear me say that?
Yeah.
The case you want is Western Trading Company versus United States. Just go to Google, look up Western Trading Company versus United States. It'll come up. In the very first paragraph, it's going to say if the assessment is not properly done, the tax is deemed not to be owing. Okay? So burn that into your brain first. Next, I have a whole packet in there explaining, there's several letters, Pastor Garth letters, okay, that are on your file, and I gave you all these files, okay?
I think that's on the website, yeah.
It's on there. Pastor Garth, how to deal with your employer, how to deal with the bank, how to deal with, the tax assessor's office downtown, all of that. It's letters to them, how to deal with it. Now, it explains in great detail. First of all, look on the assessment. Up in the left-hand corner, there has to be a number that it's a 686 paren B, small b. If it is not a 686 small b, paren B, it is not a real assessment. It's a made-up. It is what is called a notice of intent to lien. Got me?
Repeat that again. If it's a what?
If it's a 686B, it's a valid lien or assessment, okay? But they'll have 668YCS and all kind of other things out there. Those are nothing but notice of intent to lien. A notice of intent to lien is not a lien within the meaning of the Internal Revenue Code. It's nothing but a scam. Now go down in the bottom left-hand corner of the document, you're going to see two people signing the same document, except there'll be a little small FOR, which means that one person is signing on behalf of the other person. You then want to ask that IRS person, where is, or your boss at work, where's the power of attorney that says this person can sign for that person? There isn't one. Well, this is not a valid document. There has to be a power of attorney before somebody can TST and sign for another person. Can I sign for you? How about I sign a big bank company check and I sign your name? What would you think about that? I'd be in jail. That's what would be happening there because we'd be talking about forgery. But that's exactly what's going on. One person is forging the name of the other person like they have authority to do this and they have a valid power of attorney. Look on the back of the document. There's no power of attorney. Got me? Next, go to the right lower part of that document, and you're going to see somebody signing, and it says revenue agent. Okay? A revenue agent is a GS9 or below. Supposed to say GS11, collection branch manager. They never do that. They put a revenue agent down there. Revenue agent has no authority to sign an assessment. That's totally verboten. So now we have an assessment here that's totally bull. It's not even signed by a GS11 collection branch manager. It's signed by a person forging somebody else's name, and it's not even the right number for that document. If you go look in the congressional record and what they put that document down and registered as, you're going to find out unless it's a 686 small b, it's not even a valid assessment. Now, if it's not a valid assessment, we go to Western Trading Company versus United States, and it says if there's no lawful assessment, the tax is not deemed to be owing. Will that be cash or charge? Have a nice day. Hole.
Homestock.
You can tell they don't like to talk to me. And then I asked this one U.S. attorney, I was ordered to come to this meeting, the same kind of stuff, and they, or you would come down here and I'm talking to you as an attorney. I'm ordering this as a federal judge, the chief federal judge. And so I go down there and I says, let me ask you a question. Have you ever read Title 26 United States Code, Section 7851? The part where it says that the entire Internal Revenue Code was never enacted into law, that they did that deliberately so they wouldn't have to repeal the 1939 Tax Act because that's where all the collection authority was, to collect people's property. And they didn't want to lose that authority, so what they did is they just never entered an active date for when this Title 26 became law. Are you aware of that? Have you ever read Title 26 United States Code, Section 7851? I recommend you read the first 10 pages. Meticulously, back and forth, at least 10 times. Because you're going to find out this entire Title 26 United States Code is not even acted into law. You want to comment on that right now? Because you're perpetrating a felony. You're impersonating an officer, and you're claiming to be unlawful authority, and you are neither. Got me? He said, order the marshals to remove this man from my office. I hold the record, 8 minutes and 12 seconds. I'm the guy that holds the record for being removed here. And I said, oh, you must have a very excellent attorney. And he says to me, what do you mean by that? Are you threatening me? I said, sir, I was ordered to be here this morning by the Honorable Horace R. Gilmore, big round face, never smiles, has zero sense of humor, Chief Judge of the United States Federal District Court, and you're telling me you're not going to hold a meeting. I'm going to have to go back and tell him you told him to screw off and die. And then I held my fingers up and looked through the four fingers like I was looking through a jail cell, and I said, you must have a very excellent attorney. And he goes, well, no, let's not be hasty here. I think we can work this out. And I said, I would hope so, because I can tell you, Horace has zero sense of humor when you don't listen to his order, and almost always you end up in jail. But we worked it out, and he ain't bothered my client in 15 years. You see, there's always a remedy. You just got to stay calm and think. And I will tell you, God's honest truth, sometimes I didn't even know what I was going to say, and all of a sudden it just came out. So I know God has a big handle in this. I can tell you there were times where I was sitting there and I going, oh, my God, they're going to put you in a nut house in the next 10 minutes. What do you think of that? And the lawyer that they put to stand next to me says, there's nothing I can do. They're going to take it. You're going to the nut house. I said, is that a fact? When I was done, he tore his bar card in half and gave me the other half. He says, today you were an attorney. You were the most fine attorney I've ever sat next to. And by God, I'm proud enough to tear my bar card in half and give you the other half because you were an attorney today. I don't know how you pulled that off. I'm telling you right now, I couldn't have pulled that off. And he's now the chief judge in Grosse Pointe, Michigan. He said, you are an amazing person. He said, I don't know where you came up with those ideas that you presented to that psychiatrist, but you just pulled the rug out from under her. And when it was done and the judge says, I don't need to hear you. I said, now you've been here in court today. You made a determination that this gentleman doesn't understand what's going on or have the ability to defend himself. Is that correct? Well, yes, sir. And at the same time, you told me that I don't have any ability to defend myself. Isn't that correct, ma'am? And she said, yes, that's correct. And I said, well, you've had occasion to be here today. Can you, based on your observation today, make that same determination? And she went, yes, yes. And the judge says, that's it. I don't need to hear another word from her. I'm dismissing her. You don't need to say anything else. And you don't need to bring your special counsel in to defend yourself. I'm dropping this whole case. They let me go.
That's wonderful. She'll love when that happens.
I've been fortunate, 1994.
It comes right out of your mouth, and you had no control over it.
Had over control, and God just did it. He just did it. Guess what he said? I asked her if she had ever examined one of these little pocket dictionaries. And she said, yes, she had one herself in her own release. And I said, now, when you look in that dictionary and you look for a word, it doesn't always have a full definition like a regular big dictionary would have, right? And she had made a determination that I had not been fully truthful and I had not been forthcoming and given the total answers that she thought was appropriate, and that I was tangential and argued all around the moon and stuff. And I said, now, what, didn't you testify that this gentleman had been extremely courteous and never threatened you or anything, was professional and treated you at all times with great courtesy? And she said, well, yes, you did do that. And I said, and did he not answer your questions to the best of his ability, or at least try and answer the questions until you told him to stop? And she said, yeah, you did do that. And I said, well, now, let me ask you, when you look in this dictionary and you look for a word, and the word is defined by the very word you're looking for, and the bottom line is that's not significant, but that's all, this dictionary, that's all it goes to. You know what I'm saying? So you're kind of stuck with that dictionary. That's the only one you want to go to unless you go to a bigger dictionary. Isn't that right? And she goes, well, yeah, I suppose you could do that. And I said, well, isn't that what the defendant did? And she shut right up, you know, and the judge looked down at her. He says, well, would you answer the question, miss? You know? You can answer the question. And she couldn't answer the question. And that judge, that old guy, turned around. He said, look, I've heard enough from this witness. You can remove her right now. But when I asked her, are you had occasion to be here all day for this testimony? Are you still going to stand to your position that the gentleman doesn't understand what's going on, doesn't understand how the court works, doesn't have any ability to defend himself, et cetera, et cetera? That's your determination. You signed it right here. I have a copy of it right here. And that's when the judge pulled the plug on her and told her, you can step down now, honey. And I didn't go to the nut house that day. But I went other days. I hate to say it, but in the old days, it was a lot harder than it is today. Today, I hear people on talk shows all over the world talking about, we are the people, and this is the Constitution, and we got our rights, and you didn't hear that back in the day when I started. I was like John the Baptist in the wilderness, and I couldn't even speak the language. And they would just pick you up and toss you in a nut house. That's why this one guy up in Washington doesn't understand when he gets going. He really is quite good at going. But he doesn't understand. If he came to Michigan, he'd be in a nut house because they would just toss you in a nut house. We don't play with you in Michigan. This guy, Rents.
Oh, Jeff Rents?
Yeah. He's very smart. He knows what he's talking about, but he'd go right to the nut house. They just picked up talking. They've done it to me 6 times. And, of course, when they get you down to the nut house, they pretty well do whatever they want. They can try and fill you full of drugs and do all kinds of stuff. So the doctor gets me in for an interview, and right away I says, who are you? And he goes, I'm the doctor. I says, do you have an appointment? And he goes, what? I said, do you have an appointment? I only see people by appointment. And he goes, you're not on my docket. My girl hasn't put you down on my docket. And he says, I'm the doctor. I said, I don't care if you're the man from Glad. I only see people by appointment. Do you have an appointment or not? Do you see people by appointment? Well, yeah. Well, so do I. And he actually put that on the record as proof of my sanity. Now,
Okay, well,
I want you to do. I want you to be creative. Creative.
Want to take some more questions?
Go, let's do it. I hope that helped that other guy. Tell him to go to those two files. One is called Pastor Garth on filing letters to employers, banks, and what have you. And the other is the actual 112-page letter that says the entire thing is illegal as applied to me. And believe it or not, that 112-page document I read to the court from memory.
Wow.
And I'll tell you what, they stood up and took notice. I memorized the whole document and read it to them. And they had a hissy fit and had to dismiss everything. So I'm telling you, the name of the game is outwork the bounce.
Yeah.
We'll get those documents out of her file, okay? All right, let's get another question.
Okay, Southwest Florida, go ahead. You've been unmuted. Do you have a question?
Hi, Carl.
How you doing?
My question is, why is Carl such a shit-talking bullshit motherfucker son of a bitch? You're actually
Do me a favor. Can you go near a window? Because you're breaking up real bad.
I don't think we want to hear what you have to say because it sounded like you're just
mumbling to me.
Foul
and I
language.
can't understand the word. Well, was it foul language?
Okay.
It was foul language?
Yeah, I was all.
Come on now, we got ladies out here. We can't be doing foul language. I mean, I slip every now and then myself, but the bottom line is we gotta be at least professional, okay? And you damn sure can't do that to a judge.
All right. Well, next we have North and West Colorado. Go ahead. Did you have a question?
Northern California.
Oh, I've been unmuted too.
Oh, yeah,
wow.
that's. So, hold
All right,
on,
what's the question?
Buzz. Hold on, Buzz.
Yep, okay.
North and West Colorado.
That's me. Okay.
Hold on. He was first. Buzz, go ahead. Sorry.
Thank you. Hey, Constitution Man.
How you doing?
I'm fine, thank you.
Can you hear me? Can you hear me?
Yeah, I can hear you. I can hear you.
Okay.
You're a true American superhero. Is how I would say.
Well, I'm just trying to make sure everybody gets their day. And I got a little story.
You're a true American superhero.
Well, I'm trying to do the best I can to make sure every little person gets their day.
Well, thank you. And so, in that regard, I actually wanted to ask a question on behalf of somebody that I've been helping who went into unlawful detainer court today in California. And as she described it, she was laughed out of court, but I think she was a bit emotional at that point. What happened is she was served a unlawful detainer complaint, and I had prepared a jurisdictional challenge based on the fact that the attorneys will always verify the complaint themselves in California when they're suing, when they're trying to end a foreclosure and get the homeowner.
You're gonna laugh. You're gonna laugh. Don't laugh too hard on this because I really want you to look. Well, look at the papers and see if that attorney filed an appearance.
Well, in California, they don't need to. I've looked into that.
Oh, come on. You always have to file an appearance. That's the rules. If you don't file an appearance, how do I know who you are?
I know. I've looked in the rules. I haven't found anything that says they have to. And from everything that I've heard, it's just they don't have to in California.
That's ridiculous. So, well, for sure, that would be a jurisdictional defect. That would be a jurisdictional defect. Okay.
I don't disagree with you, but what I'm dealing with here is a solid jurisdictional defect, which is the attorney is verifying the complaint. Okay. And so I spent a lot of time researching this because it was for my own challenge to the unlawful detainer that was unsuccessful. But I've run it by several people, and nobody said that there's a problem with it. So this was the first time I've gotten to deploy this, which I deployed in the form of a motion to strike because it was appropriate under the rules of court. So the problem is not the complaint, the motion to strike itself. The opposition that was filed by the bank's attorney was a complete joke. It just was, they tried to, they built up a straw man and struck it down. The problem was when she went into court today, she didn't know how to force that judge to hear jurisdictional issue. The judge basically said, no, you can't do that right now. This, you know, he blew a bunch of smoke up her ass, basically, is what he did. And because she could just, you know, I tried to coach her all week. We spent a lot of time on the phone. She's in Southern California. I'm in Northern California. And, you know, I went through the same thing. And, you know, I know what it's like going through that. And she just wasn't grasping what she needed to know in order to tell that judge, you know, to go take a hike. So, in other words, basically they just laughed it off is how she described it. So my question is, what can we do to go in there? What's a real effective
Well, the
technique?
very first thing, you have to follow the court rules very meticulously, and I usually catch them on some error in that way. But one of the things that's very clear in any court you go to, if you have effectively stood there and challenged jurisdiction where they have to prove, especially standing, and in the federal courts, it's Title 28 United States Code Rule 17A1, and if they can't prove standing, they have no right to be there. And there's a bunch of cases that uphold to that. I'm trying to think of the case out there in Massachusetts. I'm a little tired.
Well, let me broaden my question.
If they can't prove, well, wait. Let's take it a little bit at a time. First of all, when we dissect this kind of stuff, you have to take it a little bit at a time. The first issue in any court battle is jurisdiction and venue, okay? Now, if she has effectively said, hey, I challenge your jurisdiction, the law says, and this is what it says in Title 5 United States Code, Section 5560, as in David, the proponent of a rule or order has the entire burden and proof of all claims made. Now, that follows up with Haynes versus Kerner, and the other one is McNutt versus General Motors Acceptance Corporation, which says once jurisdiction is timely challenged, the burden is on the claimant to make any and all proofs. And failing that, they give up the claim. Okay?
Actually, just let me clarify that this is in state court, just so you...
It doesn't matter. State court, federal court, it's the same.
Okay.
McNutt versus General Motors Acceptance Corporation is unrefutable, the leading case on it, and Haynes versus Kerner is the follow-up case. And both of them are strong as a bull, and they basically say if you have challenged jurisdiction in a timely manner, and all you have to say is I challenge jurisdiction, and it's on the record, and they haven't timely proved it, and they don't have a claim, Judge, and then he'll turn to them and say, well, what do you got to say for yourself? And usually they won't have any proof that they have any jurisdiction. Not real jurisdiction. And I don't want to hear this crap that they got the property transferred to them. Well, what Regulation Z says, that they got to give me 3 days notice of any assignments. I got no notice from these guys. I'll give you an affidavit to that effect. They didn't follow Regulation Z. They breached the contract. They have no claim against the property, right? They separated the note from the mortgage because they broke the chain of title, right? Once you break the chain of title, then we go to Christopher
with all due
versus...
respect, let me interrupt you, because I know what you're getting at, and all that's great. But the problem is a more fundamental issue, which is the judges. We got to be able to tell the judges that they're somehow, you know, they're not doing their job, because that's the problem.
I do that.
Right.
I actually put their name and sue them. That's another thing she could have done. She could have walked in with a lawsuit and said, first of all, Judge, I believe the jurisdiction of your court is $25,000. Isn't that right, at the lower district? Well, this case is a $25 million case, Judge, so you have no jurisdiction to even hear the case because it's way over your limits monetarily. Second of all, there's no way you can sit on this case, Judge, because I've named you as a defendant, sir. You must recuse yourself at this time. And then that blows him off the case.
Okay, well, yeah, that's definitely something that I've actually done that myself before. So,
well, that's what you have to do, because these judges are crooked as hell. I really think they have an interest. They have an interest in the outcome. And what I found is in the Judicial Tenure Commission in the state of Michigan, for every $18 that comes across that bench, they have so much interest in their retirement fund. Case, Judge. That's Michigan Court Rule 2.003A1, which says you can't have a financial interest in the outcome of the case.
Yeah, we have a guy here in California named, I think his name is Richard Fine. He's in Southern California, and he's been spearheading a huge campaign about that. He's been completely, you know, abused by the system, arrested, and they tried to shut him up and everything. But he's all over that. But
the biggest problem I see with all pro se litigants that are trying to fight these foreclosure cases is they don't get on the program fast enough with the lawsuit. You have to have a lawsuit, because in every state in the foreclosure law, in Michigan, it's Michigan MCLA 600.3204, and there's 4 criteria that they have before you can get a foreclosure. 1, you have to be the real party in interest with an actual interest in the case. You have to have an interest in the note, okay? 2, you can't have any legal action pending. You can't do that if the foreclosure doesn't go forward. It's blocked, okay? 3, you have to actually follow the rules of the state court in the process and time. And one of the things that they require is that you give a face-to-face meeting to the party and see if we can work out some kind of a modification here. And then 4, these guys took the car back money saying they would help people stay in their homes. They lied like hell. They played that Obama character for a sucker. And they took that money, and they're not helping people get in, stay in their house. As a matter of fact, Bank of America is giving rewards to their employees who figure ways to screw the people out of their modification. You know, there's got to be some leveling of the field here. And unless you can send a message clear as a bell to these people, hey, I will sue you, Judge, and the judge will say, oh, I got immunity. 3 judges just tried that with me. They ain't got no immunity. There's no immunity if you're violating my constitutional rights, Your Honor. Article 3, Clause 1 of the Constitution says you serve as a judge of a court of record in good behavior. You got to be in good behavior. If you're violating my constitutional rights under 42 U.S. Code 1983, 1985, and 1986, you're in good behavior, pal. On top of that, I've had occasion to pull your oath of office, and you don't have one, Judge, and I've got a certified apostille seal from the clerk of the courts that says you don't have a timely filed oath of office. Therefore, everything you rule on is bullcrap. I mean, it's not. You're a quorum non judice, Your Honor. Puerto Bail Bonds, which state of Texas says anything you sign, rule, order, or anything is moot because it doesn't exist in law. It's void ab initio. So I'm charging you, Judge, as not a lawfully seated judge. You're a quorum non judice. I'd ask you to step down out of courtesy and get off of my case. Otherwise, I'm going to have no other choice. I'm telling you now, I'll sue you. Now I'm suing the judge. And that judge sit on that bench case? No, I got to get out of here. He'll run off the bench so fast. And how I deal with the attorney is really clever. Not that I'm that clever, but I'm just telling you. I get the attorney to get in there, and he starts talking. I said, well, Your Honor, before this matter proceeds further, I would like the court to read this attorney his rights under Miranda v. Arizona, Dickerson v. United States. And he goes, what? Where is this going, counsel? I said, well, if he's going to commit a felony in your courtroom this morning and lie and get busted for perjury, I think it's only fair that he get read his rights. Man, that guy closed his case so fast, and you could hear a vacuum on that door. He cleared that courtroom, and the judge looked over and smiled. He goes, that's damn clever. I suppose you want me now to rule that he didn't appear. Bingo, Judge.
Good one. Well,
try that one. That one's a lot of fun. That guy will clear that courtroom so fast. Well, he's going to commit a felony in your court, Judge. I think you ought to at least read him his rights. That's fair. You want to be fair.
Can I switch gears to another quick question?
All right, go quick, because there's other people in line here, and we want to get them all.
I understand, but this is something that I think everybody can benefit from. So I've been labeled as one of these so-called sovereign citizens, and what I've discovered after I did a little research is that the FBI put out a memo in 2011 that, defined what these so-called sovereign citizens are supposed to be. And this went out to all local law enforcement, it seems, all over the country. And so I've had several incidents over the past, let's say, year and a couple of months, including arrests and being brought to jail and incarcerated and actually spending several days in jail for vehicle code.
Sounds to me like you were slandered, libeled, and defamed.
Absolutely.
Sounds to me like you were slandered, libeled, and defamed. I would just ask them who their attorney of record is, because you want to make sure you get the right names on the papers when we go to court.
Okay.
Now, see, I can get away with a lot more than you can, because as soon as they call me up, first of all, there's a big R13 that comes on the document which says, retired, extremely dangerous, ex-airborne ranger trained to kill, and they just get real nice after that, and it says, don't mess. And then usually when they give my name, they'll go, the Carl Miller, and he goes, well, I don't know if he's the Carl Miller, but he's one of them. And then I'll usually hear the sergeant yell, well, for God's sake, don't give that guy no ticket. He goes, Sergeant, he ain't got no plates on the car, he ain't got no license, he ain't got shit. And he goes, I don't give a damn what he ain't got. You just tell him to have a nice day and hope you don't get no papers in the mail, because that guy will drag you to the Supreme Court and sue your blah, blah, blah. Then all the cops start laughing on the radio, and then the sergeant says, all right, clear this net, get off my radio.
Okay, so you pretty much confirmed what I know I need to do. My problem is I haven't established that reputation yet, and so I'm going to ask, what do I need to do to establish a rep?
All right, well, just send him a notice of lieutenant. You're about to be sued. You slandered and libeled and defamed me. You put my name on some kind of a negative so-called hit list. You deliberately caused me great violation of my rights. False imprisonment is $1.8 million per day for false arrest, false imprisonment. I'm going to add up my damages. I'm looking at about $3 trillion here.
Okay.
You own any lakefront property? I do love lakefront property. I'll be
Very
putting
good.
liens and levies. I'll be putting liens and levies on your property come next Tuesday. So you make sure you're real careful what you're going to do, pal, because I can tell you I can be at that county seat in an hour, and I'll know every piece of property you own.
All right. Well, thanks very much for your time, and I also appreciate you helping my friend K.O. in Washington. He took over for me when I couldn't in his unlawful detainer. So
Carl? Carl? Are you talking about Carol? Oh, okay. Yeah, I'm trying to help him right now.
No,
Yeah,
I'm trying to
yeah,
help
so-
him right now.
Yeah, I appreciate you doing that because I couldn't carry on assisting him. So I appreciate you
Well,
picking up
he's
for
laid back in the weeds. His problem is he's laid back in the weeds, and he's hard to reach at times, and it's hard to see if he's actually staying on track with what I tell him. But we're getting there. We're getting there.
He's a procrastinator. He wants to make sure everything is right. So you have to tell him
I can also tell that he's an old timer, and he's going to be real careful.
Yeah, he is.
That's why I would want him to do that anyway.
Yeah, well, he has had a hard time, and he's just trying to live out the rest of his years in peace. So I
Yeah, just
appreciate
leave me the hell alone. That's right. Leave me
Exactly.
alone.
Yeah, yeah.
Go find somebody else to screw with. I'm your worst nightmare if we go to court.
He's on the call right now.
All right, give me another one.
Well, there you go. That's Constitution man Carl Miller. He's a very, very intelligent constitutional lawyer. And if you heard the beginning of it, take notes, write this stuff down because they cannot tax you. And then when they were answering questions about that guy, that was very interesting about how they like to try to manipulate you. And if you don't know what you're doing, they usually win. But hey, this is part one. There's a lot more to go. So I will put the next part up after this one. Subscribe. You guys have a great day. Love y'all. Bye.